Hey everyone, it's Rob Ryder. And today is Sunday, November 10th, 2019. T minus one to Veterans Day. Hey Vet, how you doing? Vet here. Hate to say Happy Veterans Day. It's really not a proper term, but I don't know what the salutation should be. Somber Veterans Day? But to all vets, thank you for your service. And today we're going to talk about bonds, which are security for cost. Which technically, Vet, because you've sworn an oath, you already have a bond, right? And I'll talk about that a little more as we go here. But they have all sorts of bonds. I didn't realize before. I've heard of bail bond, but they got all sorts of bonds. They have injunction bonds. They have receivership bonds. They have Lis Pendens bonds. They have bonds to take Lis Pendens, to remove a Lis Pendens. They have bonds to end an injunction. They have all sorts of bonds. Right, and you get them from bond companies. And so I kind of contacted one early on before I really understood what I know now about these bonds. And they were asking me for my BART card number, and law firm and stuff. It's like, well, why would I need those? Right? But if you're saying that I do, then that I need to be an attorney, basically to get a bond, and that would be a legal disability. And as it turns out, there's, common law relief for having a disability and so forth and so on. And then I have a case in the federal court to do with the 14th Amendment citizenship complaint, where I said the 14th Amendment had been violated. And because I wouldn't fill out the impauperous paperwork, right, basically that you're insolvent paperwork, because in common law, if you're insolvent, you don't have any rights, right? So it's like, well, no, I'm not. In fact, I'm not even really the complainant. The United States is the complainant. It's the United States law has been violated. I'm just a relator, right? That was the angle I was trying to use with them, and well, I fell on deaf ears with the magistrate judge, and so eventually it got terminated or dismissed or whatever. And then I had read about doing these things with asking for a receiver and so forth. And so I said, I'm just going to file it into the court case, ask for a receiver. So even though this case has been terminated, closed, I put it in, and I get an answer from the district court judge now, not from the magistrate judge, but from the district court judge. And then saying why he wouldn't do it. But it's like, well, okay, I can read what he says why he won't do it. So what if I undo those things? Will he do it then? So that's what I'm doing, right? I'm saying, okay, he's telling me what I need to fix for him to give me a receiver, because it's a common law remedy to have a receiver, and a common law reason to have a receiver is because you're claiming that fraud has happened. So, nothing's happened yet, but I'm hopeful. It's in. We'll see what they do with it. That's the kind of stuff we'll be talking about today. That and some other court cases I'm helping people with that all have to do with the idea of receivers and how to get one appointed and so forth. And, well, it's great to do, but it doesn't pay very well. And, because I don't have an answer to give anybody, so I'm not really trying to do this as a business. I'm just trying to pay my bills so I can continue the research and not just the research, but the doing of something with the research, because there's far too many people who just read and never do anything with it. So that isn't me. I'm a doer. Right? I read as little as I need to and send it in, and I'll see what will happen. And, then I'll duck if I need to. And it's worked so far. I'm still here. And I've learned lots of stuff about their system, and, well, this is the way I do it. So anyways, hey, my email address for Rob Ryder is courtofrecord@aol.com. No S's, and not Gmail or Yahoo or any place else. Courtofrecord@aol.com. People send my mail to other people all the time because they don't pay attention to what they're doing. Courtofrecord@aol.com. My phone number is 616-712-6179. And please, if you can help keep the lights, the internet, the phone on, a little food on the table, so forth and so on, it would be very, 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 very much appreciated, because I'm working for the common good. And you can send that to PayPal, to robryder@aol.com. That's my PayPal account name. Or you could put it in the mail to Robert Allen Retluski, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341. And remember this, equity will set you free. We just need to get into the court in equity, and they're blocking us from that because we're going not to the court that has equity jurisdiction. So when, for instance, when Jackie, a lady I'm helping from Florida in her foreclosure, when she asked the judge in a hearing that this was a court of equity, the judge stammered and blammered, but eventually came up with, no, this is a court of private law and statute. Well, then that's not the right court to be if you want equity. You need to be in a court of equity because there is a court that has equity jurisdiction. And, it's the trial court in the county. It's the state trial court. It's the state court. It's the circuit court. It's whatever it is. And it's really the same place that we're going to, I think. But what I'm seeing now is like when you go to the county clerk acting as the court clerk for the county, well, that's just the county court. But if we went to the trial court administrator, because trial court is the proper court to find equity, so we would need to get to the trial court. So I would think if we talk to the trial court administrator, hey, we should be able to find out how we have a receiver appointed. So, these are things that I've learned by looking at the paper here in the last couple of weeks. And I'm going to show you what I've seen, and next week we'll pick it up again, and we'll keep doing some more. But if I'm going to keep doing it, I need a little help. So please, stop, go to PayPal, and send me a donation. Stop, write me a check, send me a donation. Right? Just stop and send me a donation. I won't have to talk about it anymore then. Okay, so this is still mainly based around the idea of getting a receiver, because that seems to be the proper thing to do, have a receiver appointed. And one of the ways to get a receiver appointed is to have an injunction declared. And to get an injunction declared, hey, you may have to have a bond. Well, why would we want to have a receiver first? Let's go back. This is just a quick review on why you really want to have a receiver. So consideration of court-ordered receivership. This is from, it's from a attorney firm in Huntsville, Alabama. So what do attorneys have to say about this idea of receivership? Legal basis under state law and discussion on receivers' duties. Now, they do have receivership under state law, but they also have it under federal law. And the more I'm looking at this, I'm thinking, well, why not just go get it figured out for the federal system and then just take everything there? Because, in the federal system, it's all one nation under God. But nevertheless, this gave some good, reasons for having a receiver. So receivership is an equitable remedy authorized by federal or state statute and by common law. They didn't say it there, but it is. The receiver is a person appointed by a court to take possession and preserve property or a business that is involved in pending litigation so as to protect the rights of the parties until court reaches a final decision. That's what you need a receiver for. Take possession of the property until the court decides. So apparently, until a receiver is appointed, the court doesn't have possession of the property. Right? So then who's claiming to have the possession? One of the questions to ask yourself. Assuming there is a pending litigation in the federal court based on jurisdiction by federal question under 28 U.S.C. 1331 or U.S. diversity under 28 U.S.C. 1332, the court has ancillary jurisdiction to appoint a receiver pursuant to 28 U.S.C. 754. Well, that's kind of where I found myself, because on the case I filed, they put it under federal question. Now, I was trying to make the United States the plaintiff and say the U.S. was the plaintiff, U.S. government plaintiff. They denied that, or they, administrative error passed that, but instead they said it was federal question. So it's like, hey, I can have a receiver appointed, right? Because they did say it was federal question. Or diversity. Either way, you can have one. A federal court will consider federal not state common law to decide whether to grant this equitable remedy. So there's a difference between federal common law and state common law. Go figure. So what is the process? When a receiver is an appropriate equitable remedy, it is always ancillary to the primary relief sought. In other words, you're not getting the receiver just to have a receiver appointed. You're getting a receiver appointed to do a function that will lead to the ultimate remedy that you want to have done. So what is it you're trying to accomplish? What is it we're going to have the receiver do? If the plaintiff does not seek judgment against the defendant, there is no basis for the court to appoint a receiver. So there has to be a dispute. Right? It needs to be adversarial. The purpose is to prevent fraud or to preserve property during litigation. And there's the key. See, once you say it's fraud, there's a reason to have a receiver appointed. And so if you're in a foreclosure and, they're not using your name on paperwork, or they're not using their name on paperwork, and the judge says this is a court of private law and statute, you can say, well, hang on a minute, time out. I think there's fraud going on. Right? I want to have an injunction on the court case and have a receiver appointed. That would be the process that I could see using. So we're trying it right now. We'll see how it works out. The plaintiff must properly plead. So, okay, what do you need to do then? Well, the movement has a recognizable interest in the property. So tell them that you are the real party in interest to the property. Right? You do have the interest. Irreparable harm to the property will likely occur. However, immediate danger is not required in some situations. No adequate legal remedy is available. Now, this is a big one because in law, all the law side of the court can give you is money damages. But it can't change a contract, and it can't put your name on a deed, and it can't do anything other than give you money for being damaged. It can't even return you your property. It can just give you money instead of property. So that isn't an adequate remedy. If you say it isn't, so I don't want money, I want my property back. So, hey, there's a reason to have a receiver appointed. The movement has a likelihood of success on the primary relief requested in the complaint. Yeah, because we're saying it was under fraud. So if they agree it was fraud, then there's all likelihood that we'll get remedy. Insolvency may be an important consideration to be pled by the movement. Now, may be an important consideration. Does that mean whose insolvency? The movement's insolvency or the debtor's insolvency? I'm going to stay out of that one for a minute. Insolvency alone is not justification for receivership. No. What is? Fraud, right? Just claim fraud. When we're all done, no matter what else, if they're doing something to you and you think it's wrong, then it's fraud. So your claim is fraud. Examples of cases where receivership is available. Actions for injunctions to prevent removal of property in a business. Now, your name, all capital letter name, is a business. If you didn't know that, in fact, I have a FEIN for my all capital letter name as a sole proprietor, where the name of the business is Robert Allen Ritluski, and it has an FEIN number, and it's owned by Robert Allen Ritluski, and he has a SSN number. And they share the same address. And it's like, well, hey, you can't remove property from my business. I want an injunction. Action for injectment from real property. Now, this is actually what's happening in these things they call foreclosures. Because an injectment is what would be done under a mortgage. Right? But they don't have you going through an injectment hearing. They have you in some other kind of hearing. Right? On the Lis Pendens, then, it should say that you're there for an injectment. But the Lis Pendens they put in, normally, the ones I've seen, don't even say why you're there. It's like they don't have any nature and cause. So, One of the things with bonds is, well, they should have put a bond in with the Lis Pendens. We need to be asking about that bond, or put in this other bond to undo a Lis Pendens. More on those bonds in a minute, right? We're just, right now we're going to talk about this is why you want to have a receiver appointed. This is why you can have a receiver appointed and how you get it done. Action for judicial foreclosure, action for corporate accounting by minority shareholders. All right, if you want to have the books accounted and you're a minority shareholder, you can ask for a receiver. Action to dissolve a partnership. That would be these things they call a marriage. Action to dissolve a corporation. Action to set aside a fraudulent conveyance. Right? That would be the warranty deed that you have your property that doesn't have your name on it. Right? They created a thing and replaced your person with a thing. Examples of cases where receivership is not available. Unsecured creditors, refusal by an officer to let minority shareholders see corporate books. See, you can't have a receiver if you're just asking to see the books, but you can have a receiver if you're asking for an accounting of the books. It's all in the words. Other considerations. Only circuit court has jurisdiction to appoint a receiver. Now, this is in Alabama, I think it was. Requirement for a bond. A bond is required by statute. It's usually supplied by the movement, not by the appointed receiver. Oh, okay. Does that mean I need to go get a receiver bond first? Or do I need to have an injunction bond first? But apparently, you may need to have a bond. And so this is where, your oath and bond, right? Your oath will be your complaint for the injunction, because that'll be sworn to. And the bond will be the bond you bring for the injunction. You just, supply the court your oath and bond to cover your claim in court. Failure to require bond is reversible error, but it can be waived. So they don't have to have a bond. That's good. Note that in a federal case, the receiver or trustee in bankruptcy must supply his or her own bond. Okay, excellent. So if you go to federal court, the receiver has to supply their own bond. But if you're in state court, you can supply the bond and they can appoint the receiver. It's just, how much is the bond? Who's going to tell you how much the bond is? Right? Well, that would be through the trial court, because the trial court's the one that has receivers. The court of equity, which isn't necessarily the county clerk. It's the state court administrator or the trial court administrator or some other name other than clerk of the court. Or, it could be clerk of the court too. The point is, ask them both. If one doesn't have it, because this is what's happening to this lady in Georgia, the court's acting like they don't know what to do about the clerks, about a receiver. Well, it's probably true. They don't, because they're working for the county court, not the state court, which is the equity court, which is the same court, same people, just different hats. No bond is necessary. The court already has entered judgment for the plaintiff. There you go. Discussion of receiver's duties. So here's the thing. If they were to appoint a receiver, these are the things that they would do. And, well, if the business they're going to take over is your all caps, right? Because now this is more than just your house. It's like, well, hell, here's the name of my business. Here's my EIN, FEIN number. Here's my social security number. Receiver, here's the information. What else do you need? Go. Establish an account. Take control of the books. Begin a periodic report to the court. Investigate the company or individual's financial history. Value the property. Right? Demands for turnover of property. So then go tell everybody to give you the property, because it's really my property. I just can't get it because I have a disability. Right? This is what's happening. But if I had a receiver, well, my disability would be gone, because the receiver is an officer of the court. He's not working for me as an attorney. He's working for the court. So this isn't like, you talking between plaintiff and defendant. No, this is court to the accused. Sale of assets. Motion to sell free and clear, all liens, sale of jointly owned property, lump sum versus periodic payments, auction. So what are we talking about here? Well, they have created all of these negotiable instruments that you somehow have an interest in, right? But they're not paid in legal tender yet. They're bank notes, right? So it's just traded as ones and zeros as bank entry money. But they're payable in legal tender. And if a demand is put on to be paid in legal tender, they'd all have to be paid. So I'm going to do what Jesus said to do to the rich man. Go sell all your property. Well, what happens when you sell your property? They give you money. Go sell all your property, get the legal tender, and give it to the poor. And then go spend it into the economy. That's how you're going to give it to the poor. It's a wonderful system. Right, so go ahead, take all of those, take every piece of my personal property that you can monetize and turn into legal tender and do it and put it into a bank account in my name for me to use, for my use and enjoyment. Employment of professionals, right? They can hire whoever they need. General standards, motion to employ, supervise some professionals, fee arrangements. See, because what's happening is the court is actually taking control, custody of the property. So my intention is to leave it with the court and to appoint an administrator to administer my account that I own that the court is holding, right? I'm going to make the court my bank, not a commercial bank. Now, somebody had an idea, so well, with the way they read it, you can be a receiver. You can have yourself appointed as a receiver. And that may be something to do in the future, but for the beginning, I want to have, I'm going to have a professional appointed. Here, go get all these things and go sell my property. Go clear up my status. Anyways, when they get all done with this, they pay the taxes, everything done, final thing, distribution of remaining funds. That's when you get paid, right? Your 10-step process on the duties of a receiver. Basic receivership, just a little more on this, and we'll get on. A receiver is an officer of the court concerning property and receivership, holding possession of the property for the court that appointed the receiver. Things in question, pending suit, were not reasonable for either party until the litigation should be the operative person. Entity, in other words, a receiver is an officer of the court, subject only to the court's direction and control, and is a custodian, an agent whose functions are limited to the care, management, protection, operation of the property committed to its charge. Well, I'm going to give them my property. The receiver owes its allegiance to the court that appointed the receiver, but may owe fiduciary duties to each of the receiver's estate's constituents. Right? That would be us, the owners and the secured creditors. Before assuming the duties of a receiver, person, entity appointed, receiver in most jurisdictions must execute an oath, perform the duties faithfully. That's good to hear. Given the status as an officer or arm of the appointing court, receivers have been described by various courts as a temporary occupant and caretaker of the property for the courts, a medium through which the court asks, delivering his, her, its authority, or deriving his, her, or its authority from the courts, subject to court orders, control, direction, supervision, owing his, her, its allegiance only to the court, responsible primarily to the appointing court, and accountable directly to the appointing court in the performance of his, her, its duties, and a fiduciary of the appointing court. Because people have tried to make the judge the fiduciary before. He says, I'm not your fiduciary. These are some of these stories I've heard over the past. It's like, okay, that doesn't mean they can't appoint one for the court, but it isn't the judge. You need to get the judge to appoint a receiver, and then he's the fiduciary. Receivers' acts are the acts of the court. Well, it'd be like, court orders. A receiver is not, however, a representative of the state and does not possess the receivership property in a sovereign capacity. That's interesting. A receiver is not, however, a representative of the state. All right, so he's not a state officer, he's a court officer. And does not possess the receivership property in a sovereign capacity. Well, does he represent the church then if he doesn't represent the state? I think he has to, because we're talking the Court of Chancery, which, used to be run by the church. It was created by the church. It was created by the Catholic Church. This whole English system, English common law, was created by the Catholic Church out of Rome. What people say is Roman law was created by Constantinople. That's Greek. Right? Roman civil law is Constantinople. English common law is created by the Pope and the bishops out of Rome. A receiver is not the representative or agent of any party involved in litigation in any sense, not even the party who procured his or her appointment, but represents only the appointing court. Typically, a receiver stands in position of representative or protector of the interest in all who claim an interest. Okay, as you can see, lots of good things, and I don't want this video to get too long talking about receivers because there's other things to talk about. So let me go find this thing on bonds real quick and get that covered. Hang on just a second here. Okie dokie. So, how do you get a bond? Well, you go to a surety bond authority or similar company. They got an 800 number. I think this one's in California. It's funny, one of them I got a hold of is in Puerto Rico. That's the one I ended up contacting for some reason. And but it says all 50 states, Puerto Rico, Virgin Islands, da-da-da-da-da. But I like this site because if you go to Surety Bond Authority, right, .com, that's the name of it, and go under types of surety bonds, you got court bonds, construction bonds, commercial bonds, license and permit bonds, and all I've really looked at so far is just the court bonds. And so I just click on it and look at the whole list of them. All right, simply put, court bonds are used to minimize losses resulting from a court ruling or to ensure compliance with court-mandated actions. Court bonds can be split into two subcategories, judicial bonds and fiduciary bonds. Judicial bonds protect involved parties against uncertainties involved in many proceedings. Typically, they are intended to limit the losses that could result from a court ruling. Fiduciary bonds are designed for circumstances when the court appoints an individual to care for others or manage others' assets. These bonds ensure the court-appointed caretaker ethically adheres to their legal designated duties. So, you got a judicial bond, that would be like for an injunction, and then the fiduciary bond, that would be like for the receiver. So here are some of the most common types of judicial bonds. You got your appeal bond, you got your bail bond. Hey, most people may know what a bail bond is, or have heard of one, but you got a cost bond. It is a plaintiff's surety bond that guarantees the plaintiff, non-resident of the jurisdiction, will pay all the expenses in the litigation. Now, on each of these, on this site, if you click on this, it takes you to another page. It's just full of all, a bunch more information on that particular style of bond. And goes on and on and on. And I'm thinking about this because it's talking about for non-resident of the jurisdiction. Well, I've tried to open up cases in Washington, D.C. before, and I didn't put in a bond, right? And I'm not a resident of that jurisdiction, so it's like, oh, maybe I had to have a cost bond and open the case in D.C., right? So if you're going to open it in a non-resident jurisdiction, you got to have a cost surety bond. Simple enough. All right, how do you get one? You call a bonding agent, I guess. We're not quite there yet. Injunction bond. This is a bond required by the plaintiff in an injunction civil case. The bond guarantees that the plaintiff will indemnify the defendant against any damages sustained as a result of the injunction, and the court decides the injunction wrongfully restrained the defendant. And so in my head, I'm thinking, well, I'm going to be using injunction bonds for people. You think about this, that this would be for somebody who has some kind of court action or government action going against them, or foreclosure, or the banks are coming after you, or whatever it is, to make them stop. Go have an injunction issued, and then appoint a receiver. Because apparently there's a clouded title to the property because these other persons, they think they have a right to the property. So injunction bond. Now here's a Lis Pendens Bond. For plaintiffs wishing to block the sale of property, the surety bond serves as a guarantee that has been filed, that they have filed a claim on the sale of the property and done it in good faith or not under false representation. So if you're in a foreclosure, did the opposing plaintiff's attorney, did they file a bond? Because I have seen the Lis Pendenses before, but where's the bond to go with it? Because you have a right to question the bond as the defendant. Lis Pendens is an official constructive notice. Lis Pendens means when you need to use a Lis Pendens. Example, different types of surety bond. Technically, Lis Pendens bond is used by plaintiffs to block a defendant's sale of the property, and in doing so guarantees the plaintiff is not filing claims in bad faith. Well, there you go. They put a Lis Pendens in, but they don't say what it's for, and then whoever they're representing doesn't really have any interest in the property in the first place. However, defendants have an option of recourse if they decide to sell the property but cannot do so, plaintiff blocking rights to sell. This is where a release of Lis Pendens bonds come in. Oh, they got a release. So the first thing is to ask them if they have one, I guess. And if they did have one, then you could go in here. Because I don't think they're putting these in. I don't believe it's been filed yet. But they have a release of Lis Pendens bond. They got a replevin bond. It goes on and on and on. They got administrator bond. Temporary restraining order bond. Executor bond, guardianship bond. I remember in Terry's case, they were talking about there being a guardianship file, right? And by God, there's a guardianship bond. There's a receivership bond. So right now, the court has a guardian appointed. We want to have a receiver appointed. Because you look at all these, it's like, well, these are being used in the equity side, other than money damage side of the court, where things other than money need to be paid out, and that's what you need the bond for. It's like, well, all these are being used in the court of equity. So we need to go to the court of equity. Okay, and so I had found an example of, right here's an injunction bond from Merchants Bonding Company. Known all persons by these presents that we, whoever the principal is, which I believe that would be you, we, Robert Allen Berlusky, or do we need to have more than one? I don't know, but we, and the bonding company, as surety, are held firm bound onto blank in the penal sum of some number of dollars, for payment of which, well and truly to be made, we do jointly and severally bind ourselves, our heirs, executors, assigns, firmly by these presents. The condition of the above obligation is such that whereas the said blank has filed in the office of the clerk of the district court, blank county, state of blank, a petition praying that a writ of injunction be issued to, right? So I guess this is who you want to have it against. Whereas the honorable somebody or other, right? Da 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 da. So it's almost like, well, this is something the court should be giving you, right? Because where are you going to get all this information from? For this bottom, especially court number, yada yada yada. So either the bonding company you're working with knows how to do this already, right? This bond is available for purchase at bondrepublic.com. So I don't know how you fill in all the blanks yet. I'm just saying this is all it is to an injunction bond. Well, fine, go get one. Get an injunction bond, and then as part of your relief in the injunction, ask for a receiver to be appointed. But since this is, just one of the styles of court bonds, and a bail bond is a style of a court bond, then can a bail bondsman offer you these other bonds? Can he give you an injunction bond? Can he give you a Lis Pendens Bond? Now, Jackie, who I'm helping in Florida, she's already called on this Lis Pendens Bond. Maybe she was asking the court. I don't know that we had actually defined the bond we were looking for at this point. But they got to the question. Her says, well, you probably shouldn't do that unless you have collateral. And so she left it at that and went on, da 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 da. But, what is the collateral? Well, the collateral is the property that's in the court case. So you have collateral. You're the real property and interest. So you need to tell them, no, I have collateral. That's my property. That's my collateral. Right? I claim it's mine. I'm the real party in interest. So if they ask about collateral, the collateral is whatever else is what's already in the court case. That's the collateral. The res of the case is the collateral. Okay, so we saw that, and we saw what one looks like. So good enough. Now, here recently, I'm helping a lady out in Georgia. So it's where we wrote this up to the Tiffin Judicial Circuit Superior Courts, because that appears to be the proper name. I mean, you never really know with this stuff, right? NRE, that was her. Name of the city, name of the county, Georgia, United States, application for injunction and appointment of receiver. And out of the Georgia law, it says in there about the appointment of a receiver, grounds generally, when any funds or property in litigation and the rights of either or both parties cannot otherwise be fully protected, or where there is a fund or property having no one to manage it, a receiver of the same may be appointed by the judge of the superior court having jurisdiction thereof. Excellent. We want to have a receiver appointed because they confiscated her property. And so basically what happened is helicopter went over her house. In Georgia, marijuana is, well, they call it marijuana. First of all, don't ever call it marijuana. But marijuana is still illegal, so they busted her. 18 plants, and they came into her house, took all of her property, took her deceased husband's gun collection, gold coins, all sorts of shit, just, and out the door they went. Well, it's hard for people to accept this, but it is what the Bible says. And in Genesis, right, it says book 1, really it'd be on the very first page of the Bible, depending on how big a pages your Bible has. And God said, Genesis 1:29, and then God said, I give you every seed-bearing plant on the face of the whole earth. Every seed-bearing plant on the face of the whole earth, and every tree that has fruit with seed in it. There will be yours for food. They will be yours for food. And to all the beasts of the earth, and all the birds in the sky, and all the creatures that move along the ground, everything that has the breath of life in it, I give every green plant for food. There's no law against marijuana. That would be a violation of your freedom of religion. Because the Christian religion says that's food, and the court can't keep it from you. So don't let them call it marijuana. The other thing is marijuana is not an English word. You don't need to know what marijuana means. That's a Spanish word. So anyways, we said I, state your name, full legal name, applicant, and a permanent resident of the county that she was in, apply for an injunction and appointment of a receiver as a remedy of last resort in litigation involving the conduct of executive agencies that fail to comply with constitutional or statutory obligations to populations that rely on these agencies for their basic human rights, and to protect my person's, papers, houses, and effects from tangible and intangible property, from unreasonable searches and seizures. Now that, sentence there, as crazy as it sounds, that just comes out of the definition of receivership from Wikipedia. Right, so I don't think these things up, and I just copy and paste. Receiverships are also a remedy of last resort in litigation involving the conduct of executive agencies that fail to comply with constitutional or statutory obligations to populations that rely on those agencies for their basic human rights. So in other words, we have people pretending to be law enforcement that aren't. Well, or if they are, then they're violating good faith because they're not upholding the Constitution. They're trying to enforce an unconstitutional law. A number of documents that simulate a legal process under color of law were initiated by persons having no affiliation with the sheriff, state police, or federal law enforcement in order to camouflage their armed trespass to persons' property land. So they fly a helicopter over, they say, hey, there's some plants in that garden, we're going to go ahead, they're just about ready to be harvested. Now's a good time to land. They come, they don't land, but they send in the drug enforcement people who turns out they're not affiliated with the sheriff's department. Right? They're a private police force of some kind. Now I'm saying chances are they don't have any kind of certificate from the Georgia law enforcement standards, whatever they call it in Georgia. In Michigan it's called the Michigan Commission on Law Enforcement Standards, which actually gives out a certificate that says, hey, you can be a law enforcement officer. And without it, hey, you can't be a law enforcement officer. I don't believe that these people have that kind of stuff, right? They're not affiliated with the sheriff. It's a private entity created by some of the fucktards over at the county. This is a way to, shake down the people and make some extra cash. So they take all these plants, they take all this woman's husband's gun collection, shitload of bullets, gold coins, da-da-da-da, just there it goes. Been confiscated. And so there's a whole story behind this, and I don't really have her permission to tell the whole story, but I'm just tell you what we're doing about it at this point. So anyway, all this has already happened, so now we're going to go. She took this to the court and said she wanted to have an injunction, right? My liberty and personal property were seized and my identity stole by individuals impersonating Georgia law enforcement officers claiming authority to enforce an unconstitutional statute that violates my freedom of religion protected by the Constitution of the United States. They can't take green plants with seeds away from you. Ever. Don't let them do it. While held against my will in a private prison, I was coerced into accepting responsibility for indebtedness as part of a scheme to extort my wealth because they won't let you out of court till you sign the damn bond. Right? What did you do when you signed the bond? You created more property. Well, now there's a dispute on who the ownership is. An individual impersonating a Georgia district attorney posted a partial inventory of property unjustly confiscated from my person, but I never received proper notice as required by law. This posting used the pseudonym, so they didn't use her full legal name, like they didn't use her middle name, right? So that isn't her, which is legally insufficient as identification, and make no mention of the gold or silver coins seized without proper warrant. I have not been made aware of any formal charges or Georgia court proceedings against my person or property, and I demand relief from this breach of the public trust and acts of bad faith. So this was First, I had written up like a answer to the charges that really hadn't even been given to her yet. They had just taken her property. Was supposed to go to the, the charge was supposed to go to the grand jury. None of this had happened yet when we answered the first time. But they have never sent her any paperwork, right? What they did is they took this inventory they made and they posted it in a bulletin board in the courthouse. Now, it doesn't have her name on it, and it wasn't done by the district attorney. It was done by some assistant district attorney impersonating the district attorney. And in neither case did they use the names, the full legal name of the district attorney or the by attorney that was putting it up there. So, it doesn't have the real name of the defendant. It doesn't have the real name of the district attorney, and it doesn't have the real name of the assistant district attorney. Well, there's just something wrong with that, right? And the funny thing is that when you look closer at it, it says on there that it's for $25,000 or less. And I can see why that is now, because if it was $25,000 or more, it would have to go to the trial court, because the trial court has jurisdiction in civil matters over $25,000. Below $25,000, it doesn't have to go to the trial court. But it's the trial court that has equity jurisdiction, so we want it to go to the trial court. And they're keeping it out of the trial court in the county court. Right? Because this is a judicial district that has, 4, 5, 6 counties in it, and we're dealing with one county. And this county has a clerk of the court for the county. So that's how I think they're keeping us out. They're having us, deal with county court people who don't know what the state court does. And the state court's actually the trial court, and they have a person called the trial court administrator, or the state court administrator, or someone else other than the clerk of the court that administers the higher court in the county. And so that person has to know how to have a receiver appointed. That's going to be what we're telling them next week when we talk to them. But in the meantime, since this is asking for an injunction, I got to get a hold of this lady and say, hey, we need to see if get a hold of a bondsman, probably the same guy who wrote the bonds for your bail bond, and tell him you need an injunction bond. If they won't give you one, well, then that's a legal disability. And we'll talk about that in just a second. So let me grab some more papers. Hang on a second. Okay, so this is Lake County, Florida, right? Lake County Clerk, Florida. So not the state of Florida, but Lake County Clerk, Florida. Court case that Jackie in Florida is involved in, where it was the United States of America acting through Rural Housing Services, right? That's supposed to be the name of the party. Well, that isn't the name of any United States entity. That's just a bunch of words put together to make it look like it's supposed to be the United States entity. Because I wanted to show, see, it says here, full name, and then they have all of these blah, blah, blahs. Well, these are, the full name of whatever it is they're talking about. And so the judge is trying to mail some paperwork out that has been sent back, and we'll look at it, where it has the judge's name in the return mail section, right, that's using these names as the name of the entity. So it's not using Victoria. Which one? Where are you in here? Yeah, Jacqueline Victoria Veazey, right? They have her name in here. Veazey, a.k.a. Jacqueline Victoria Veazey, a.k.a. Jacqueline Veazey, Jacqueline V. Now, who the hell is that? Right? That isn't anybody's name. That isn't identifying anybody. But they want Jacqueline to agree to be, that person. Well, she hasn't gotten any mail in this name sent to her. She hasn't gotten any mail in any name sent to her from the court. So if this is on here, what address are they using for this entity? Because apparently that mail isn't getting returned because it's not being put into the docket. And I'll show you what I'm talking about here now, right? But I wanted to show you these different names they're using. And so here's the docket with all these different entries, and there's 81 entries. So if we go back to where were we when I got involved in this thing? Okay, first of all, they had this mail returned. Let's look at that. Right, Heidi Davis, Circuit Court Judge, Lake County Courthouse. Right there she is. Well, she's in the return mail spot on the envelope, and it's being sent to the Federal Deposit Insurance Corporation. I guess I can turn it around. You can't do it from here. Why can't I rotate this damn thing? Oh, here it is. The Federal Deposit Corporation, Insurance Corporation, as receiver for Colonial Bank, right to that entity. And they said, hey, this return to sender doesn't exist. Well, who was the sender? Heidi Davis. What was she sending? She was sending order granting judicial default. Well, how come the defendant didn't get one then? They're supposed to serve all the parties. Right, so it's like, okay, well, there's that. So these things had happened just before I got involved in her court case. But it was on 10/15 that we put in a motion for lead to file a petition of right, filed pro se by defendant. Well, that's what we did. That's what they said, that we did it pro se. We didn't. Actually, we're up here. Motion for lead to file bill of petition of right. That was the first thing we did. Well, it just so happened that later on the 14th, I think it was, or the 15th, they had a hearing, and that's where Jackie asked them, is this a court of equity? And they said, Judge Stammer said, well, no, this is a court of private law and statute. Okay, so soon after that then is when I figured out, hey, we need to be asking for an application to have a receiver appointed. Right here, number 76. But as you can see, after they had the hearing, they issued this order to dismiss the defendant's motions. So then they did a certificate of service. Then we put it in our application, which, it looks like this. Notice, I, Jacqueline Victoria VZ, make application to the Circuit Court for appointment of a receiver in accordance with law and Florida Rule Civil Procedure 1.620. I have properly noticed the attorney for the plaintiff in accordance with Florida Rule Civil Procedure 1.610. Right? Filed it in. There it is. Put into the court case. It's like, okay, well, we already have a court case, so now we just want to have a receiver appointed. Well, part of that was we sent a copy to the judge also, and then the judge put it in. Right, so here's the same thing now, received by Heidi Davis, Circuit Court Judge, and she put it into the court case, but she called it text. She didn't call it an application. And then they set this hearing saying that on December 10th, we're going to have a hearing guess we should just read it. Notice of hearing. Please take notice that on December 10th, or sooner thereafter as counsel can be heard, the undersigned will bring on to be heard the defendant's application, appointment of receiver, file 10-23-19, before the Honorable Heidi Davis, one of the judges of the above court, at the Lake County Judicial Center in Chambers, 2nd floor, North Wing, Suite 5, located at 550 West Main Street, Travis Lake County, Florida. Please conform the hearing location with the bailiff upon arrival. I certify a copy of the furnished, blah, 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 blah. And then I had this note at the bottom, and we'll get into that. Because if you are a person with a disability who needs any accommodation in order to participate in this proceeding, you're entitled at no cost to you to provisions of certain assistance. Then they go on and talk about contacting the ADA coordinator of the trial court administrator's office. Right? So, what did they say here? That they're going to have a hearing on something that was put in on 1023. Well, on 1023, text was put in. And it wasn't filed by the defendant, Jacqueline Veazey. There is no defendant, Jacqueline Veazey. See, they're trying to set up a little scheme here at the end. And this is no different, although it's different how they're doing it, than what they did to Terry, this lady I was helping in Wisconsin, her court case, where we got a motion set for their to be heard for her court case, and they said to be on the 4th floor. Da-da-da-da. Terry goes up there on the day of the hearing, 4th floor. All the lights are off. She walks up the court door and looks, and turns around to walk back, and somebody pops out of nowhere and says, "Hey, can I help you?" Right? Enter from stage left. Here comes an actor. "Can I help you?" "Yeah, I'm supposed to have a hearing up here today." "Oh, yeah. Well, they're having all those on the 2nd floor today." "Yeah, I don't know what happened. Something happened. Yeah, 2nd floor. Just about that time, stage right. Next actor comes in. Said, "You know what? I'm here for the same reason. I heard the same thing. They're down on the 2nd floor. So let's all go down the 2nd floor." So they lead her down the 2nd floor, and sure enough, that's where they have a hearing. But what happened is Terry didn't appear in the courtroom she was supposed to at the time she was supposed to be there, and, it was a scheme. Well, that's what this is. They want to have a hearing on text, not a hearing on an application. Text filed by defendant Jacqueline Veazey. Well, Terry isn't the defendant. She's a real party in interest. Saying that none of these other people, because, here's the defendants, right? These are all the parties. She's saying, look, I'm none of these people, right? I'm the real party in interest, and I'm here to stake my claim. Right? I want a receiver appointed. Why? Well, because she claims an interest in the property. So they're trying to, there is some little scheme going on. But then they talked about this here. So this is where we're at now. We're going to contact the state court administrator or trial court administrator and tell them, we need to have a receiver appointed. So, but it said disability, right? So now what is a disability? Well, the ADA, the Americans with Disability Act, it has its definitions of disabilities. But this isn't in the sentence about the ADA. It's a sentence all by itself with just the common law disability, right? Just a lowercase word, disability, which in law, according to Bouvier's, which is the dictionary used to define the words for the Constitution or something like that. I mean, that's kind of how it's portrayed. I really don't know. All I know is a disability is want of legal capacity to do a thing. Person may be under disability to make a contract or to bring an action. Well, I'm saying that's our problem. We can't bring an action in our full legal name. They're not allowing us to do it. And now if the bail bondsman or the bondsman won't give us a bond to have an injunction or to cover the cost of a court case, well, that's another disability. These would all be disabilities. See what I'm saying? More than just, I need a wheelchair ramp or something like that. No, you have a legal disability. Those who want understanding as idiots, lunatics, drunkards, and infants, or freedom to exercise their will as married women and persons in duress, or who, in consequence of their situation, are forbidden by the policy of the law to enter into contracts as trustees, executors, administrators, guardians, are under disabilities to make contracts. That's why you need to have a receiver, because he can do a contract. The disabilities to sue are alienage, where the alien is an enemy, right? So enemy aliens, infancy, by the laws of England. There are other disabilities. These are outlawry, attainder, praemunion, popish recusancy. What? Recusancy? Monarchism? Jeepers. So I'm saying that, because there's gold fringe flags in the courtroom, we're actually under martial law right now, under the Lieber Code, and so, we may have a legal disability. Well, we need to tell the trial court, hey, I got a legal disability. Because they made sure to make this, plain as day. I don't know that this was on her documents before. I'd have to go back and look at them all. Right? But there it is. And then they talk about here that you could do this by, basically, if you call this phone number here, non-local parties wishing to appear should contact court call at this number. Court call is some service where you can, appear in court over your telephone. So that's what's happened in her case. We are filing for a receiver. And now, knowing what we know, because this is supposed to be a foreclosure, well, that's what we can look at. So if we go back now, look at her court case, go back to the docket. Lis Pendens. Hey, there it is. What did they put in? Notice of Lis Pendens. Notice is hereby given of the institution, the above entitled court, above entitled cause by the above named plaintiff against the above named defendants involving the following described property situated in uppercase Lake County, Florida, right? Not propercase Lake County. And that was, I gotta go back and look at one of these other ones where they did everything right in the address except they made Lake in Lake County just like this. They uppercase, where all the other words have been proper case. Okay, so if they put in a Lis Pendens, then where's the bond? Notice is hereby given the institution in the above entitled court. So where is the above entitled court? In the circuit court of the 5th Judicial Circuit in and for Lake County, comma, Florida, and there's no case number. Right? There's a number over here, and there's shit up at the top, but, this is where the filing starts, here, and there's nothing in there. And I don't see where it says it's that it's for a foreclosure. It just says that there's a notice of Lis Pendens of the above styled cause. What? Where's the above styled cause? It doesn't say it's a foreclosure. In fact, let me look. There's no fees on here. That's interesting. Recording fees. No, nothing. So they didn't record it. I don't believe they recorded anything for free. It was filed, but it wasn't recorded. Interesting stuff. So if anything, this went into like the county court, not into the circuit court. And if it's in either court, well then where's the damn where are these things at here? Here we go. Where's the surety bond? Where's the court bond? Right? Where's Lis Pendens Bond? And if there is one, well, then get a release of Lis Pendens. If they won't let you do these things, well, then you must have a disability, and you got to tell the trial court administrator, I can't bond the case. Right? That's the biggest problem. We can't bond it. If we could bond it, well, then we would win. And I don't believe they put in a Lis Pendens Bond, because if they did, they'd have to be, following the up and up, and they're not doing that. What else did I want to show? Those are gone. That. Hang on just a second. Okie dokie. So, just real quickly, because I'm helping somebody in Utah a little bit on a foreclosure, where we had found, or she had found there that talking about receivership, that one of the main reasons we're having receivership is to quiet the title of the property. And so I'm looking through she had almost all of her documents. She had the main ones that I needed to see. One of which was the purchase agreement, because the purchase agreement says on it what's going to happen to transfer title. And the purchase agreement is really the only document in a real estate transaction that has both parties signing the contract with witnesses. The buyer signs it, the seller signs it, and the agents sign it. And there isn't anything else that does that. Well, in the agreement, it talks about what it's going to take to have title transferred, and it talks about a general warranty deed, and you go and look in Utah, and they give the form of the warranty deed that's supposed to be used. And, so then you take this and you compare it to the warranty deed that a person has, and you would see that warrants to, and then it says insert name, right? Now, that name, it would be like Robert Allen Ritluski, but normally that's what they should put, but they don't put that. They put a thing. They put Robert A. Ritluski, comma, a single man, right? So they messed that line up. But then they completely don't have anything in there to insert place of residence, right? Of wherever. So it should say Robert A. Ritluski of whatever the name of my city is or whatever it is. Well, when you look at the warranty deeds in Utah, they don't have this whole section right here is missing, right? So they're not, it's like that, right? So basically, they are not giving you the warranty deed that the law says that you should have had, and therefore your title isn't quiet, and you need to have the title quieted. So you just show the judge the warranty deed, say this doesn't conform to the law. I need to have a receiver appointed, to figure out the rights, titles, and interests of the property. Okay, that's all on that little one. What I did want to show, though, was what I have going. In the federal court, U.S. District Court, Eastern District of Michigan, in Bay City, civil docket case 119 CV 11243-TLL-PTM, Ritluski versus Bay County, County of. In other words, County of Bay. And then this is the civil docket sheet up until there's one more entry now. This is where I put in my application for a receiver. And then there's another entry, which is the order that came from that. We're going to get into those right now. So this is what's going on with this thing. I had originally filed on a civil cover sheet trying to make the U.S. government the plaintiff, right, and me the relator for the plaintiff. And so then the attorney for the plaintiff is the U.S. Department of Justice. That makes sense, right? Basis jurisdiction, U.S. government plaintiff. The defendants was the County of Bay, right? Which, you look them up online and you find out I don't know where I got their corporate counsel from. Oh, I think that was just on the county website. Right, so I wasn't making this to be a diversity or federal question or U.S. government defendant. I wanted the U.S. government to be the plaintiff, me to be the relator. If that was the case, because the U.S. is the plaintiff, well, they don't have to pay for the court case. Right, other civil rights. Checked. Original proceeding, 42 U.S.C. 1983, civil rights for civil action for deprivation of rights, cause of action. trespass on case, malfeasance. And malfeasance has a particular definition that I used it for, and I could just easily put fraud. That's what I should put. Cause of action, fraud. So that'll all clear itself out, but that was that. And, with that cover sheet goes your complaint, and this is on the Pro Se 15, which is a complaint form that's already made out for violation of civil rights, non-prisoner. Right? So anybody could use this one if this was to work. Of course, right? And so you fill it out, you get the one that has the drop downs online, and you put in all these things you need. Now, like mine, I think this would be Northern Division. Blah, 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 blah. All right. Provide information for each plaintiff. Okay, that was me. County of Bay. State or local officials. Violation of 14th Amendment to the United States Constitution. U.S. citizenship automatically granted to any person born within this and subject to the jurisdiction of the United States. You know what? I need one more piece of paper. I'm sorry. I gotta go get it. Okie dokie. So anyways, I was saying it was a violation of the 14th Amendment. And you're supposed to use the 1983, the 42 U.S.C. 1983, right? For violation of the federal Constitution by, state or local officials. And I said that the County of Bay is a business. It does have a Dun & Bradstreet number, right? So if you look for County of Bay on Dun & Bradstreet, you'll find it. It is not an administrative subdivision of Michigan. That would be Bay County. No, it's County of Bay. Its officers did not recite an oath of office mandated by the Constitution of the United States or Constitution of Michigan, 1963, nor subscribed by full legal name. County of Bay operates in violation of the Michigan Penal Code, false impersonation, right? Their legal process, impersonation, false representation, or action as public officer or employee, because these people called the County of Bay are not the fucking government. Right? That they're a business. I don't even know if they're a properly formed business, but they're not the government. And they didn't take the oath of office that's in the Michigan Constitution. They didn't use their full legal name on it. So they're in violation of this penal code, which is false impersonation. They're claiming to be somebody that they're not. Where did this happen? Well, it happened in Bay County, Michigan, United States, on September 7, 1958. So what are the facts? Well, according to a certain certified copy of record of birth, the clerk of the County of Bay and the circuit court thereof certified that the record of birth of Robert Allen Rutluski and the whole thereof is remaining in the clerk's office. All right, this official record evidenced Bay County, Michigan, United States as birthplace. The date of birth of Robert Allen Rutluski is September 5th, 1958, and the creation of a record on June 25th, 1963. The official record evidences that the birth record of Robert Allen Rutluski was not made known to the United States as proof and evidence that Robert Allen Rutluski is subject to the United States by birth and entitled to American nationality. By malfeasance act, the clerk concealed the whole birth record in his office and did not inform the United States of the newborn subject. Unlike our United States was denied a subject while a realtor was denied his American nationality and ownership rights, titles, and interests in private property in the United States due a U.S. citizen. Should actually be citizen of the United States. If I was to do it again, I'd be putting citizen of the United States because that's what the 14th Amendment says. Accounts and records have been concealed from the plaintiff, relator, right? The plaintiff, that's the United States, relator, and the world that Robert Allen Rutluski is a U.S. citizen subject to the United States. Realtor is denied his internationally recognized venue, the United States, and plaintiff is denied the sovereign's taxes from its subject as defined by the Constitution of the United States and Act of Congress. Relator's right of self-determination to be recognized as a U.S. citizen is denied by him by County of Bay, State of Michigan, United States of America, a foreign venue with no authority in the United States. Right? County of Bay, State of Michigan, United States of America is not the same as Bay County, Michigan, United States. Right? They do this on purpose. They take Bay County, they turn it into the County of Bay. Take Michigan, make it State of Michigan. Or they take the term State of Michigan and say, well, that's the name of something. But State of Michigan with the S capitalized and the M capitalized are really also just two proper nouns connected by a connecting word. State, meaning it's properly organized, and its name is Michigan. But it's not called State of Michigan, it's Michigan. Bay County, Michigan. Not County of Bay, State of Michigan. And certainly not County of Bay, State of Michigan, United States of America. United States of America is claimed by King George III's successors in the Treaty of Peace from 1783. Right? That's what he used to call it. Plaintiff later claim writ of right to seek complete remedy and equity, blah, 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 blah. So this is what I had put in. Right? And, well, then they took it and they gave it a court case number and, they gave it a docket. And, say, that's cool. I got a docket number and now we can put papers in. But they didn't make the United States the plaintiff. Now, on the one I did for Terry, they did make the United States the plaintiff and her the plaintiff. Right? On hers, they have both United States up here. There's a big space in between. Then it says United States. But it's represented by the wrong person, right? It shouldn't be represented by me. It should be represented by the Attorney General. And I'm not pro se. So what they did, they took what I had filed in, and they made the jurisdiction federal question instead of U.S. plaintiff, U.S. government plaintiff. But from what we read earlier, because they did this, right, and they made it federal question, well, then I can have a receiver appointed. I can have an injunction. So, that's how this thing had gone, and I put in trying to get some changes made, trying to do anything I could, claims of unconstitutionality, anything short of filling out the damn paperwork saying I was a pauper. So I never did it, and they dismissed the case. Well, then they issued a judgment. Well, then I put in an application, and where's the one? Well, and they put an answer in. So this is all I did. This is what I put in, right? Asking for receiver, appointment of receiver. Plaintiff requests a receiver be appointed over these proceedings. Well, the damn thing's already closed, right? But I didn't care. I put it in anyways. We'll see what they say. Well, it didn't take long after it was put in to get an answer from the judge, right? This is coming from the judge now. Ordered to deny an application for appointment of receiver. And this is where we have to start paying attention to what they're saying. Because on April 24, 2019, plaintiff Robert Rytlewski, right, not Robert Allen Rytlewski, so there's an error, filed a complaint against the defendant, Bay County, against the County of Bay. The complaint alleges the defendant violated the 14th Amendment by not informing the United States government of plaintiff's birth in 1958. That part I agree with. Right, that's an ECF number 1. That'd be the complaint. Plaintiff claimed that this prevented him from being recognized as an American citizen. No, I claimed it from being recognized as a citizen of the United States. And we should look at that real quick too. 14th Amendment. Right, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, right? Citizens of the United States and the state wherein they reside. No state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States, lowercase c, citizens of the United States, nor shall any state deprive any person of life, liberty, property without due process, nor deny to any person within its jurisdiction the equal protection of the laws. Well, that's the shit that's happening right now. I'm being denied those things. Then I must not be considered a citizen of the United States, because that you can't deny him to a citizen of the United States. So what does that mean? It means, well, even though I was born, I'm not subject to the jurisdiction. That'd be like a Native American, like Pocahontas, right? That gal that she's running for, president, whatever the hell her name is, right? She claims to be an Indian. Well, all that means is she was born here, but she doesn't claim to be subject to the jurisdiction of the United States. Yet she wants to be its president. Well, that's true enough. She doesn't have a proper oath of office, so she's not holding an office, right? But so the thing is, well, how come I'm not a citizen of the United States? How come these things are happening to me? Well, I say it's because of this. When I look at my certified copy of record of birth, it says that I, Stephen Toth, clerk of the County of Bay, right? County of Bay, and the circuit court thereof, the same being a court of record, having a seal, do hereby certify that the following is a copy of the record of birth of Robert Allen Bretluski, full legal name. Don't care if it's in all caps. What I care about is there's no initials or no nicknames. It's Robert Allen Bretluski. Yes, I own that. That's my property. Now remaining in my office, in the whole thereof. Right? So the record of my birth never left the office of the clerk of the County of Bay. Well, then the United States doesn't know that I exist. Maybe that's what the problem is. That's what I said, right? That, that's malfeasance on their part. They kept my records in their court. They didn't give them to the United States. Now, it goes on further. Most everybody has a certificate of live birth, right? COLB. Some people have one of these certified copies of record of birth. But I've never met anybody that has a birth certificate that actually says birth certificate. But that's what everybody talks about. So I don't know what a birth certificate is. But I know what a certificate of live birth is, and this is the form that gets filled in when they're doing the Vital Statistics Act. And so in Michigan, within 5 days of the event of the birth, it's supposed to have been registered with the state registrar. Well, here's mine, September 5th, 1958. But it shows here that it wasn't received by the local registrar until September 18th, like 13 days after the event. Well, if the local registrar didn't get it to the 18th, then the state didn't get it till after that, because the state would have got it from him. Which means that this document was made legally ineffective because it wasn't filed within 5 days. And, if it was never changed, then it was never done properly. It's just sitting there in a fucked up record. Well, that's what I have. I got a screwed up record. Because it didn't make it there in time. And the evidence of the rest of the record then is being kept in this, right? Record 2137, Liber F, page 2137, October 7, 1958. So that's the property, whatever in that record. But back to this. So I put that in, right? So now he's denying it. He denied Robert Bretluski, but Robert Bretluski didn't file anything. He went on to say, then in accordance with 28 U.S.C., whatever number it is, 636B, the case was referred to Magistrate Judge Morris for general case management. EFC 6, court adopted Judge Morris's report and recommendation. EFC 11, denied for insufficiency plaintiff's request for forma pauperis status. Plaintiff was directed to pay filing fee and warned that the failure to pay would result in dismissal of his case. Complaint was dismissed for failure to pay the filing fee. All right, that's all chronologically correct. The reason it happened isn't necessarily something I agree with, but, there's chronologically, that's what happened in the second paragraph. So now, we're to today. Now before the court is plaintiff's application for appointment of receiver. ECF number 15. The application states in total, plaintiff requests a receiver be appointed over these proceedings. That's all I put. I did that on purpose. I'm going to say as little as possible and see how they answer. And this is how they answered. Plaintiff provides no factual basis or legal authority for the relief requested. Additionally, the case has been closed for over 2 months. The application will be denied. Accordingly, it is ordered the plaintiff's application for appointment of receiver, ECF 15, number 15, is denied. And this first time I saw one of these on here where they actually put a little proof of service document right on the paperwork. So, okay, so hopefully they go away. Hang on just a second. Okay, so the application was denied. Well, I have a choice of accepting the answer the way it is and doing nothing else, or, saying, well, hey, hang on a minute. What did he tell me? The reason it was being denied was because it gave no factual basis or legal authority for the relief requested. So I wrote up I called it a notice of administrative errors in ECF number 16, the one the judge put in, and an amended application. So now I've sent this back, and I'm waiting to see if they're going to file it. They sent it last Monday, right? So tomorrow, the Veterans Day will be a week, but Veterans Day is a holiday. It won't be open. So it'll be Tuesday, I guess, before I hear anything. Or later. I don't know. We'll see if they even put it in the court case. Take notice. I, Robert Allen Rutluski, the applicant requesting federal equity receiver, am an oath-bound, honorably discharged enlisted veteran of the United States Armed Forces. I am the real party in interest in this proceeding, and I do not consent to the misidentification of my person or erroneous interpretation of my original complaint as seemed to be implied in ECF number 16, order denying application for appointment of receiver. So I'm going to say, hey, there's some errors in here. I don't agree with this. All right, so I don't know. Should I call it an objection, an appeal, a notice? I'll call it a notice. Notice of adjudicative facts. That Robert Rutluski is legally insufficient style of identification for Robert Allen Rutluski. The defendant is County of Bay, identified by his Dun & Bradstreet registration number. County of Bay, State of Michigan, United States of America, not Bay County. Plaintiff claims defendant committed fraud because fraud is a reason to have a receiver appointed. Remember that. It's a common law reason because you're claiming fraud. The 14th Amendment makes no mention of American citizens. Robert Allen Rutluski claims the status of a citizen of the United States as intended by the 14th Amendment. The style of case number, right, that the judge used, 19-11243 and ECF 16, differs from previous filings. The oath sworn by the alleged clerk of the County of Bay conceals the full legal name of the actor impersonating an elected county clerk, whose oath is not the oath mandated by the Constitution of Michigan of 1963 and does not satisfy the 6th Article of the Constitution of the United States. The clerk of the County of Bay is either falsely sworn or swore an oath of a foreign power and is engaged in insurrection against the United States, which is really what's happening. We're at war in the United States. There's gold fringe flags in all these courtrooms. Civil War's never ended, been under martial law since 1863, and there's nobody holding an office that actually has the proper authority to hold the office. They're not constitutionally empowered people. We're under martial law. Well, they're not using their name on the oath that they're taking, which is unconstitutional. It's not satisfying the Constitution. It may be satisfying the occupying military government, but they expect you to use your full legal name. You can't hide your name. If you hide your name during a time of war, that's considered an act of a spy or saboteur. It's in the DoD Law of War Manual. Right? So, yeah, we're at war. Gold fringe flags. All these things are happening. And this person is impersonating an elected county clerk because that isn't the office they're holding. During a time of war, all of these offices are suspended. You don't have an election for a county clerk. The clerk of County Bay has either falsely sworn or swore an oath of foreign power and is engaged in insurrection against the United States. Gold and yellow fringe flags in courtrooms and chapels, all churches have gold fringe flags in them. Evidence that the United States is at war and governed by martial law. Our constitutional form of government is suspended, and the nation's capital is overrun by persons who swore an unconstitutional oath and impersonate members of Congress and commission officers of the United States. I've shown this in many, many videos. I've shown the actual paper. It's true. An accusation of fraud, bad faith, or breach of the public trust, treason, or other felonies is sufficient authorization for reopening a closed case. I would agree, right? There was no statute of limitation on fraud. Claim fraud, open the case. The applicant, petitioner, plaintiff is the realtor for the United States, and both are damaged parties. So I'm trying to give them the facts of why they have a receiver appointed. The administrative errors in the first paragraph of ECF 16 have left the plaintiff insecure in this person's papers, houses, and effects from unreasonable seizures, causing injustices that must be corrected. Take notice of Federal Rule Criminal Procedure 66 receivers. Let me go get those real quick. I don't have those open yet. Hang on. Okay, so anyways, what it says in Federal Rule 66 receivers is these rules, what rules? Well, the federal rules govern an action in which the appointment of a receiver is sought. So these rules must govern equity because that's what receivers are in. They're from this equity side of the court. These rules govern an action in which the appointment of a receiver is sought or a receiver sues or is sued. But the practice in administering an estate by a receiver or similar court-appointed officer must accord with the historical practices in federal courts or with the local rule or with a local rule. An action in which a receiver has been appointed may be dismissed only by court order. What that is saying is, that this court has equity jurisdiction, that it can appoint a clerk or it can appoint a receiver, and if it does, it's within the historical practices in federal courts. Well, that would be by common law. Or with a local court rule. Well, historical practices in federal courts, what will we say that is? And that's by precedents or by a local court rule. Okay, now there's one thing prior to receiver, which is injunction and restraining orders, which is really what we're going to try to do. All right, we need to have an injunction. There's a section down here about security. The court may issue a preliminary injunction or temporary restraining order only if the movement gives security in the amount the court considers proper to pay the costs and damages sustained by any party found to have wrongfully enjoined or restrained. The United States, its officers and agencies are not required to give security. We are. So we need to give this court an injunction bond to have an injunction. But based on having an injunction, that would be the reason to go to the court. So this is its own reason to go to court, just to have an injunction issued. Forget that there's another court case. I'm already in a court case that they've said is federal jurisdiction, so for that reason I can have a receiver. But if you go in and put in the cost for an injunction, which is determined by the court, so the bonding people have to know what it is already. What is the the amount of the bond to satisfy Federal Rule 65C. I think they have to have done it before. Okay, so that's where we're at. So I'm getting a receiver because I already have a case that's been considered federal question. The other way is to have an injunction issued, and to have an injunction issued under Rule 65 would require that you have put up the cost, which is that receiver's, is the injunction bond, gotten from a bonding agent who may do bail bonds, but ask him if he can do an injunction bond. So yeah, we're going to have an answer for this stuff next week. Don't worry about it. Or if they won't let you do it, well, now you have a disability and you need to go to the trial court administrator and say, I have a disability, I can't bond this case. They won't issue me a bond. So we'll find out. Plaintiff does not have adequate remedy at law. Only equity can provide complete relief. That's one reason for having a receiver appointed, right? Because I don't have a remedy at law. I'm not looking for money damages. I'm looking to have records changed and property secured and property transferred and da-da-da-da-da. Accusations of fraud enable the appointment of a receiver. That's a common law reason all by itself to have a receiver appointed. County of Bay members have committed acts of bad faith, breach of the public trust, fraud, requiring ecclesiastic jurisdiction and a court of equity. Michigan court rule, well, this would be a local court rule, states that upon the motion of a party or on its own initiative and for good cause shown, the court may appoint a receiver as provided by law. I can use Michigan rules with the federal court. You know, they got to follow the Michigan rules, so there you are. But in Title 28 United States Code, 28 U.S.C. 3101 and 3103 allow the appointment of a receiver as a prejudgment remedy when a debt is owed to the United States. You can go read it yourself. Persons bound by U.S. oath owe a debt to the United States. So I say, and the clerk of the County of Bay swore an oath to the United States, so they say. So did the relator, so I say, right? So I owe a debt to the United States, therefore they can appoint a receiver. As a veteran, oath-bound enlisted member of the United States Armed Forces, the relator is guaranteed privileges, maintains his enlisted status, and represents the United States. And the United States wants to have a receiver appointed. Sure, they didn't see this one coming. Plaintiff is baptized Christian, and a receiver can compel the United States Conference of Catholic Bishops, the USCCB, to comply with Canon 96 of the Code of Canon Law of 1983. Go figure, the bishops don't follow their own canon law, or that's how it looks. But then we don't seem to follow our civil law, so really there's no difference. It's, we're not going to the right door to get them to do it, apparently, because the law is written. And Canon 96 of the Code of Canon Law of 1983 says that by baptism, one is incorporated into the Church of Christ and constituted a person in it. And it goes on to say some other stuff, right? But by baptism, one is incorporated in. Well, if you're going to be incorporated into something, then what is the thing you're being incorporated into? Right? The Church of Christ is some kind of association. It's a voluntary association. I'm being incorporated into the voluntary association and constituted a person in it. But they won't register me in the Church of Christ, which isn't the 501c3 that they talk about. This is, something through canon law, which, the USCCB has been authorized by the federal government to exist under its laws, and it's got a law that says under Canon 96, a baptized Christian is going to be incorporated into the Church of Christ. Well, they didn't do it yet because I don't have any evidence that I've been incorporated. Where's my certificate? I think this is where your spiritual person goes. You have a legal person, a natural person, and a spiritual person. Or you have an artificial person and a natural person and a spiritual person. All caps is your legal person, right? Your proper case name is your natural person, and Uh, your name Christian, and your middle name, I guess, is your spiritual person. I don't know. It could be that's where, mine comes in. My confirmation name is Robert Allen Michael Ritluski. Anyways, I want to be put in there. I want them to go make the UCCB do something. So as noted in the original complaint, real and personal and mixed property that the relator applicant, that would be me, claims an interest in, now suffers clouded titles, and the relator's civil rights and liberties are being suppressed because something as simple as registering a birth was made ineffective for fraudulent purposes. It was purposely done incorrectly, and that's fraud. Right? It's the omission of a material fact. Other errors or omission in official records are sure to be or to need correction. That's why I need to have one appointed. An effective federal equity receiver could correct all records, unite the trinity of the relator's natural, legal, and spiritual persons, sell all personal property that can be converted to legal tender, and deposit in an account for the benefit of the relator to more easily give to the poor. Where's my debit card? My credit card, right? You're going to be paying off the debit or the credit. No, the debit with your credit. We're going to take it from one set of books and put it in another. That's how I see this. Also, we're going to be able to secure the relator's Geneva Convention ID card and all other relief courts of equity jurisdiction has to offer the United States and its relators. Please appoint a receiver, have them contact me. There's much work to do. Staff Sergeant Robert Allen Ritluski, veteran, USA. Did you know that if you're a veteran enlisted, you're still in the military? They never let you go. You're still in the military. I'm still a staff sergeant. I may be a veteran of the United States Army, but I'm still a staff sergeant. You don't want to be a mister. A mister doesn't have any rights, titles, and interest in this system, right? That's not really the proper title to have. So if you were enlisted, you should be using your enlisted rank. So anyways, this is what I'm trying, because I have a case open and it's free, right? Put it in, waiting to see what they come back with for an answer. They haven't done it yet, but it took them a week or so last time to put something in, so I'm figuring the first part of next week I'll get some kind of reply. But I think I can have a receiver because I'm giving him what he asked for now, right? He said the reason I couldn't have one before, I provided no factual basis or legal authority. Well, I gave him factual basis and legal authority now. So claim it's fraud, that's the factual basis. Claim it's fraud, say that's the authority basis. After that, we just go to the dictionary, Judge. But, I can do better. I can give you some more. I can show you what it says that, in Michigan court rule, since again, this is their rule saying these things. That, where's 66 here? 66. These rules govern an action in which the appointment of a receiver is sought, or a receiver sues or is sued. But the practice in administering an estate by a receiver or similar court-appointed officer must accord with the historical practice in federal courts or with a local rule. An action in which a receiver has been appointed may be dismissed only by a court order. So basically, the court can write an order, a rule, to the receiver to take your property and do this to it, right? And then it would be being administered by the receiver in the way that the court wants it done. But the court would then, they would have custody of the property, and you would be the owner of the property in custody of the court. So now the court's protecting your property. I just think it's an untapped avenue. And so I'm trying it as a 14th Amendment citizen action. But you can just as easily, where was that? Here. Right? Because your warranty deed is defective because they didn't put in this part here, whatever it is they ended up not doing to cloud the title to your property, to have it quieted. And if the bank is coming after you now saying, hey, you're behind, you got to make these payments. Well, who are they, first of all? Whatever, put an injunction against them. But the way to get the injunction so that it's just the same for everybody would be to do it through the federal government. And the federal government says you got to put up costs for a bond. And hey, they have a name for it. It's called an injunction bond. So that's what we're going to try to do, is figure out how to have these bonds issued that if they won't issue it to you, then you definitely have a legal disability. You're not being allowed to bond a case. You're not being allowed to bring a case to court. But whatever you do, if you do these things, make sure they're using your full legal name. Or if they don't do it, make sure you call the trial court administrator and say, hey, they're not letting me bond the case. So, a couple other points since I'm here. Here's the injunction bond. So this is the bond required by the plaintiff in an injunction civil case. So this is the bond that should satisfy Federal Rules of Civil Procedure, Rule 65C. That's the bond you need. What your injunction is for is dependent on what they give it to you, but it's the same. I mean, the plaintiff is going to ask the court to make somebody stop something. So it's the same for everybody. If you're wrong and they have a right to do it, well, then you had to have the bond. But if you're not right and they do this, well, then you had to have the bond to take care of the other guy's cost. But if you're right, you don't need a bond. You got a Lis Pendens Bond. If you're in a foreclosure, ask to see the Lis Pendens Bond. I'm sure they don't have one, right? But file into the court case and ask for it. Get a hold of the plaintiff's attorney. Ask for the Lis Pendens Bond. But when you find out, they don't have this and you're in a foreclosure, then go get the injunction bond and go to the federal court and have an injunction put on the court case at the state court. That's what I'm, advocating trying here. So, okay, hey, I rambled a lot today, and that's because, none of this is in stone. It's all fluid and going all the time. So, but what isn't fluid is the fact that I need money. That's all the time I need money. So if you can, please help. Keep the lights on. The internet, the phone, so forth and so on. Rob Ryder at PayPal, or send it in the mail. Equity will set you free. I'm a believer. Okay, y'all have a great day now. Happy Veterans Day. Veterans tomorrow. We'll see you.